good morning to everyone who has joined us. Thank you very much for joining us so promptly. Welcome to the Landmark Chambers Public Law Update webinar. We are delighted to see so very many of you joining the session today, and I very much hope that you will find the presentation and the discussion to be useful and informative. Now, our very popular Public Law Update is intended to be an update as to the key lessons from the key public law cases in the last 12 months. My name is Carine Patry KC. I'm a public lawyer doing a very wide range of public law work, and I will chair the session today. It was intended to be someone else, but unfortunately they couldn't join us this morning, so I've taken over. I'll be joined by my colleagues Miranda Butler and Charles Bishop, who I will introduce formally in just a moment. But before I do that, just a few housekeeping matters to note. The first thing to say is that your microphones are automatically muted on this webinar, so you don't need to adjust your settings. The second thing is we really do welcome questions throughout the session. The best way to submit them is via text in the question and answer session, which could be found either at the top or the bottom of your screen. It's the bottom on mine, but it may be different on yours. It is entirely possible to remain anonymous when asking a question. You just have to tick the send anonymously box before submitting your question. Thirdly, this webinar is recorded, so if you need to leave, we encourage you to stay, but if you need to leave halfway through, you will receive a link to both the presentation and the recording shortly after the event concludes. And then finally, if your connection is lost at any point during the webinar, we invite you just to rejoin the meeting using the original link once more. I think that's it for housekeeping. One more thing before I introduce Charles and Miranda. One of the key public law cases of this year is obviously the For Women Scotland Supreme Court decision. It's arguably one of the most significant public law cases that we've had since our last update because of the complexity of that case. But it pretty much needs a seminar of its own, and we won't be discussing it today. But I would draw your attention to a very good blog post written by a barrister called Crash Wigley, which is on the UK Constitutional Law website. Very recent. It's called For Women Scotland, A Case of Significant Silences. And we can, I'm sure, send you the link to that blog post when we send you the link to everything else. So let us begin. I'm going to introduce our two speakers today, starting with Miranda, because she's going to speak first. Miranda has a broad public law practice with a particular interest in trafficking, immigration, and human rights matters. She was recently appointed, she'll kill me for saying this, but as one of the youngest ever deputy upper tribunal judges in the Immigration and Asylum Chamber. In 2024, she was also nominated for Legal Aid Barrister of the Year. And Charles is one of our very junior tenants. He practices across all areas of public planning and environmental law. He's ranked as a rising star in the Legal 500 and is also listed in Planning Magazine's top junior barristers. He's regularly involved in all sorts of high-profile judicial review cases, including last year's challenge to the government's emergency ban on puberty blockers. And I hope they won't mind me saying they're also two of the loveliest people you could ever hope to meet. And I'm very, very much looking forward to what they have to say today. So without further ado, I'm going to hand over to Miranda, who's going to give the part one of the update. Thank you.
Thank you very much for that far too generous introduction, Carine. So I'm going to be talking about a mishmash of issues. We're going to touch on rationality. We're going to touch on anonymity. And there is a surprise announcement at the end, which will be exciting only to myself. So starting with rationality, there have been two interesting, slightly contrasting cases recently, one from the Supreme Court and one from Mr. Justice Chamberlain in the Administrative Court. The one from the Supreme Court is the Spitalfields Historic Building Trust case. This is a case about a planning decision taken by a local authority's development committee. It was not a local authority, a council. The council's standing orders provided that members who had not been present at an earlier meeting were unable to vote on a matter that had been the subject of a vote at a first meeting, and therefore this committee held a first meeting at which several people voted in favour of an application. The matter was adjourned, and only 3 of the members who attended the second meeting for the final vote were able to vote under that standing order, and they allowed the application by 2-1. The Historic Building Trust objected to that grant of the planning application, arguing that if all members had been permitted by the standing orders to vote, the outcome would have been different. The reason why this perhaps quite parochial issue reached the heights of the Supreme Court is because the appellant trust argued that the powers and the statutory principles under which local authorities and councils make their standing orders cannot be read so as to preclude councillors, who are, of course, elected by members of the public, from voting, thereby indirectly disenfranchising the public who voted for them. And the Supreme Court rejected that argument, and they rejected it because they'd been invited by the appellant to essentially read down the fairly straightforward language of the relevant statutes, with the effect that they would prevent any infringement of the right to vote, because the appellant argued this was a fundamental, essentially common law right that shouldn't be undercut absent express wording, applying the principle of legality, or alternatively that the court should look at this matter as one involving fundamental rights, namely the right to vote. The court rejected that, said the right of a councillor to vote cannot be regarded as absolute or fundamental. Whilst the power to make standing orders is subject to the normal constraints of public law, there is no heightened scrutiny, otherwise known as anxious scrutiny here, nor is the principle of legality engaged, because the right of councillors to vote on businesses of the local authority is not an established right recognised by the common law outside the statutory regime of which it forms part. Now, this is interesting and sits potentially in a little bit of tension both with the case I'm going to come on to discuss and also previous Supreme Court jurisprudence. So, for instance, in Osborne and the Parole Board, Lord Reid took a more dynamic approach to the concept of fundamental rights, and the court at least appeared in that case, which concerned fairness in parole board hearings, to be more open to common law rights interacting with rights created under statute. Whereas here, there was much more of a bifurcation. It was held that the common law hadn't recognised a right to vote as a fundamental right. However important the right to vote might be under various statutory frameworks, that did not mean that it was an established right capable of engaging the principle of legality or requiring anxious scrutiny of the making of standing orders. So we can contrast that case potentially with a case at first instance, which is the case of KP. This is one case amongst much litigation that has arisen out of the treatment of Sri Lankan Tamils on Diego Garcia and the British Indian Ocean Territory. This individual in particular, who had quite a significant criminal record, had been refused entry into the UK, even though he was being detained on Diego Garcia in very concerning circumstances, and even though it was agreed that he couldn't be sent back to Sri Lanka, and even though there was at that stage no third country willing or able to take him. And essentially, this was a straightforward rationality challenge to the Secretary of State's view that he could remain on Diego Garcia for the foreseeable, in the hope, essentially, that a third country would agree to take him. And Mr. Justice Chamberlain concluded that the Secretary of State's view to that effect was, in fact, reasonable. And in undertaking that rationality review, Mr. Justice Chamberlain goes through a very thoughtful and nuanced assessment of the principles of rationality. He doesn't follow an approach which requires the identification of an established common law right, as we've seen in Spitalfields. Instead, he says essentially that the intensity of review in a rationality case varies depending on the importance of the interests affected by it. That doesn't necessarily, he says, require the identification of a right, but rather involves the court focusing on the gravity of the consequences. So whilst, of course, I'm not going to invite everybody to start telling the Supreme Court it's wrong because Mr. Justice Chamberlain has taken a slightly different approach at first instance, I still think this is an interesting bifurcation in approach coming from one of our most senior and most thoughtful judges. And certainly, I think in an appropriate case might be an interesting point to be put to the Supreme Court, because this does potentially allow for a bit more nuance and flexibility. Mr. Justice Chamberlain went on to explain that where a sufficiently grave consequences might follow, where a sufficiently important right is engaged, and therefore anxious scrutiny applies, that requires the court to undertake a rigorous examination of the defendant's processes and identify whether there is what he refers to as process rationality. That includes making sure that every factor which might tell in favour of an applicant has been properly taken into account. No irrelevant considerations have been taken into account, for instance. He also looked at the concept of outcome irrationality. Essentially, have you reached a substantively unreasonable conclusion? And he said, in looking at the outcome, a court will require more by way of justification from a defendant where there are sufficiently important interests affected. And in appropriate cases, there may actually only be one reasonable outcome open to a decision maker. So there could be very little latitude for a decision maker in an appropriate case. However, when looking at outcome irrationality, that isn't just a question of how severely is the individual affected. The court also has to look at the importance of the public interest on the other side of the balance. And in applying that analysis, the court may well have to show institutional deference to the democratic credentials of a government and or their particular expertise in the matter. Here, it was held that there was particular expertise on the part of the FCDO in assessing whether a third country was likely to take KP. And in those circumstances, Mr. Justice Chamberlain's view was essentially the conclusion reached by the government had been reasonable, notwithstanding the gravity of the consequences for the individual. So I think this will very much remain a fertile area for us all to watch. Moving on to a slightly more procedural issue, anonymity. And my suggestion here is that anonymity orders are going to get harder to justify. Firstly, we can look at the case of Abbasi. This is a number of joined cases arising out of the tragic scenario whereby hospital trusts, which have been treating extremely ill, very young children, had unfortunately ended up engaging in litigation with parents of those children, particularly around withdrawal of treatment for them. So we're talking about an incredibly sensitive issue. And in these cases, whilst the babies and children were alive, the court made an anonymity order protecting the identities both of the families involved, but also of the treating clinicians. Very sadly, as often happens in these cases, the children did subsequently die. And the question was, what should be done in terms of the anonymity orders that have been made? Because understandably, parents who may have very strong views about how their children had been treated and cared for may well want to publicize their cases and go to the media. And they can't do that without identifying themselves and identifying the clinical teams in question. The Supreme Court held that, firstly, on a jurisdictional basis, held that High Court does have a power to make anonymity orders both whilst a child is alive and after they've passed away. And that's both under its inherent jurisdiction and under what's called the Broadmoor jurisdiction to ensure that public bodies are able to discharge their statutory responsibilities. Also separately, a clinician who, for instance, brought a claim based on their private life interests could potentially obtain an order for anonymity that way. Then in terms of the principles to be applied, the Supreme Court, perhaps unsurprisingly, held that the court needed to undertake a balancing exercise between Articles 8 and 10 in these cases, even if it's a case between private individuals, given the horizontal effect of the ECHR. The court emphasised that best practice for anonymity orders is that they shouldn't be of indefinite duration, that the orders, although obviously in an anonymised fashion, should identify the persons being anonymised, and there should be sufficient provision made for clinicians affected by an order to be notified if it's being granted and also if it's being discharged. In this case, all the injunctions were discharged, which perhaps you will already have noticed, given the fact that the relevant clinicians are named in the name of this case. And it emphasised that, firstly, it's for clinicians, not hospital trusts, to seek reporting restrictions after the death of a child. That generic evidence, for instance, of the very sad harassment and abuse that's happened in some of the particularly high-profile cases, like the Charlie Gard case, is not particularly pertinent in making such an application. You need specific individualized evidence. That any restriction on freedom of expression had to be established convincingly, so essentially it's quite a high burden to show in order to obtain anonymity, and that permanent anonymity for all hospital staff would be disproportionate. And in this case, where there was a low risk of what the court referred to as a social media storm, it simply wasn't necessary to maintain the permanent injunctions anymore. Similarly, again, at first instance, Mr. Justice Fordham, in a case called Al-Nur, refused anonymity to a recognised refugee who was also a potential victim of trafficking. And I think that perhaps historically there has slightly been practice whereby somebody who has a trafficking claim, someone who's at some stage in the asylum process, even having been recognised, will sort of de facto think that they're entitled to anonymity. And I think this is an important reminder that that isn't automatic, although asylum seekers in most cases will be entitled to anonymity. So the fact that you're a recognised refugee doesn't of itself justify anonymity, because in principle you are entitled to remain in the UK. There's no risk if you're being removed and identified. Similarly, whilst there is statutory anonymity for victims of trafficking under the Sexual Offences Amendment Act, that applies to trafficking committed by British citizens in the UK or elsewhere, and any trafficking that takes place in the UK. So if, as in the case of Mr. Al-Nur, you'd been trafficked outside the UK by non-British citizens, you didn't have a statutory entitlement. Far be it from me to question Mr. Justice Fordham, I do think there is a question as to how principled the distinction is if that cohort has statutory anonymity and somebody who just happens to have been trafficked by a non-British national isn't entitled to that anonymity. But in this case, Mr. Justice Fordham's explanation was essentially that there just wasn't a risk to this individual from identification. And I think this really reflects the strong push that we also see in the Admin Court Guide in favour of freedom of expression and against anonymity orders. And indeed, Mr. Justice Chamberlain decided to help us out last night at an ALBA seminar, just reminding us of procedurally what anonymity orders should cover. They should include a withholding order stating that the individual's name should be withheld and that they should be referred to by a cipher. I didn't know this until Mr. Justice Chamberlain told us. The Administrative Court Office chooses the cipher. It's not for us to decide. You also need to include a reporting restriction referring to the Contempt of Court Act. And you also need to refer to the public's right of access to redacted documents on the court file under CPR 5.4c. Quickly, a warning that I'm sure none of the expert attendees need. There's been a case recently regarding wasted costs orders made against a barrister and solicitors for misrepresenting the law in their proceedings, including by relying on 5 authorities which simply did not exist. Mr. Justice Ritchie has written a very robust judgment, which deserves reading, in which he found that this was improper, unreasonable, and negligent. And he shows some skepticism about the argument that this wasn't the result of an AI hallucination, albeit he doesn't make any such finding that this was necessarily created by AI, but that's certainly an issue that has been seen elsewhere with AI-generated legal arguments. I'm sure some of the solicitors on this webinar will be a bit surprised that a statement of facts and grounds prepared by a barrister in a barrister's name containing false citations was the basis of a wasted cost order against the solicitors, but Mr. Justice Ritchie emphasised that it is the responsibility of the whole team to make sure that pleadings are correct. So an important reminder to us all. I'm not going to trespass on Charles's time because I know he's got a lot to cover as well. So I'm going to leave a few other interesting cases to note on this slide about amenability, about delay, and about procedural fairness. And before I leave, I promised you a great reveal, very exciting, only for me. This year is 25 years since the Human Rights Act came into force. And as a way of marking that, Landmark Chambers, together with LexisNexis, are publishing a new practitioner guide on the law and practice of human rights. My absolutely wonderful colleagues have been working, I can assure you, night and day on the book. And we hope to have it launched on the 2nd of October, which is the date on which the Human Rights Act came into force. I'm already finding it incredibly useful just reading all the wonderful material everyone has produced. And I hope everyone will enjoy the book when it comes out. But now I'm going to pass over to Charles.
Well, thank you, Miranda. I'm going to cover 4 topics, and I can assure you none of these cases have been made up, although I was thinking that might have been quite a fun engagement exercise to include a fake case and see if you could spot the difference, but I'm not going to do that. These are all real cases, surprising or not. I'm going to cover first law and policies and looking at the Prince Harry case, and then the law and consultation in the Liberty case. Both of those were Court of Appeal judgments that were handed down on Friday last week. Then I'm going to look at a series of Supreme Court cases to do with breaches of procedural requirements contained in statute or secondary legislation and what that means for the decision that's been taken. And then finally, just going to briefly look at some guidance from Mr. Justice Chamberlain as the judge in charge of the Administrative Court on when it is appropriate to order a rolled up hearing. So policies, an area that has generated huge amounts of litigation in the last few years, and we've had probably our most significant case on policies since the Good Law Project case in 2022, which was about government policy in relation to WhatsApp conversations. But just as a quick recap, generally policies are not law, don't create strict legal rights, but interpretation of a policy is for the court. So if a decision maker misinterprets a policy, then that can give rise to a legal claim. Challenges to policies were considered and streamlined in the A decision in the Supreme Court a few years ago, which kind of restated the law and made it a bit harder for a court to strike down a policy as being unlawful. Generally, public authorities are under a duty to comply with policies, but that is subject to 2 caveats. The first is not all policies that are called policies are in law a policy that gives rise to any duty on a public authority, and that derives from the WhatsApp case, the Good Law Project, and I've included in this slide a paragraph about that. And then the second reason why a public authority is not under a duty to comply with its policies is when that public authority is permitted to depart from that policy. And that was the subject of the decision in the Duke of Sussex Prince Harry case, which was about the adequacy of the protective security arrangements that was applying to Prince Harry since he formally departed from official duties in the royal family and was returning to the UK post-COVID in June 2021. The security arrangements are organised by the Executive Committee for the Protection of Royalty and Public Figures, or RAVEC, as more interestingly called. And in relation to Prince Harry, RAVEC had decided not to follow its ordinary policy that applied to public figures. And central issue in the challenge before the Court of Appeal was, well, what's the standard of review by which the court can scrutinise a decision of a public authority not to follow its policy? And in essence, the Court of Appeal said that the question is whether RAVEC had a good reason to depart from its policy. And it was not, as the Secretary of State had contended, whether RAVEC had acted unreasonably in the Wednesbury sense. So it's not a rationality test, but that doesn't mean that principles applicable in the rationality context might not be relevant. So the Master of the Rolls summarized the overarching approach as being essentially where you consider first where on the spectrum of policies this policy lies. So is it a policy which is particularly strict in a particularly less sensitive area, in which case the court will be more ready to intervene and establish that there has not been a good reason to depart from the policy. So in this context, national and royal security, the court was to be particularly astute to respect the experts in their field, because that is not an area that the courts would be particularly expert in. The other aspect of it is to consider the decision itself. So what kind of decision was taken? And so you introduce into that issues relating to deference. So really, we're talking about another aspect of rationality review that Miranda was discussing as arising from the Supreme Court decision in, Josh, I think the slides have disappeared from my screen. If we go back to what Miranda was saying in the Supreme Court decision in Spitalfields and the Chamberlain judgment in KP, that was focusing on aspects relating to rights, but there can also be deference and a different approach to rationality arising from the subject matter in issue as well. So was the kind of decision that was taken an issue that requires the courts to apply deference to the approach of the decision maker? So we're seeing here rationality on a sliding scale. Sorry about losing the slides there. That was, I think I accidentally hit the escape button. So that was the Prince Harry case. Ultimately, the Court of Appeal said that Ravik did have a good reason to depart from its policy in that case. And in particular, Prince Harry's situation was so unique that it was particularly astute to not intervene too heavily in what Ravik had decided. So moving on to the Liberty judgment, and this, I'm going to focus on the aspect of the judgment concerned with the law and consultation. So on this slide, I've just got a recap of the law of consultation. Main point to take from this is that there is no general duty to consult, but a duty can arise from statute or common law. And in a case in Court of Appeal called Coughlin, it had been said in passing that whether or not a consultation is a legal requirement, if it is embarked upon, it must be carried out properly in accordance with the Gunning principles. And this had been taken to mean that if, and really without question until more recently, that if a public authority voluntarily undertakes consultation, then you're basically in the Gunning criteria, and that consultation is challengeable. And if it's not been carried out fairly, then that might be a successful judicial review. So the Liberty case concerned powers of the police to impose conditions on public processions and assemblies, and those could be exercised where the responsible police officer reasonably believed that a procession or assembly may result in serious disruption to the life of the community. In 2022, Parliament gave the Secretary of State power to make provisions by secondary legislation as to the meaning of the conditions giving rise to the police's power. And in 2023, she made regulations so as to provide that the power could be exercised in specified circumstances where the disruption was more than minor. So serious disruption was defined as meaning more than minor disruption. And Liberty brought a judicial review claim against those regulations, and it succeeded in the court below, where it was found that the regulations were ultra vires and that the government had conducted a one-sided and unfair consultation process. And the Court of Appeal heard the Secretary of State's appeal against those two findings. But ultimately, that appeal was unsuccessful, but not in relation to the consultation grant. The Court of Appeal agreed with the Secretary of State that the High Court had got it wrong on the consultation point, but it didn't matter because the High Court was still right on the ultra vires point. So on the consultation ground, the essential issue was whether a consultation had actually been carried out in law at all prior to the regulations, and if so, what that required. Liberty didn't argue that there was actually a duty to consult here, but rather that a voluntary consultation had taken place. And so following that principle and Coughlin case that I mentioned, it was required to be carried out in accordance with the gunning principles. But the Court of Appeal rejected the argument that a voluntary consultation had been carried out at all. So that gives rise to the question, well, when is a consultation not actually a consultation? And really, the most recent case on this had been, until now, the Evely judgment from the Court of Appeal in 2023, which explained that there is no magic word in the word consultation. It's a word which in ordinary usage has a range of meanings, but the mere use of that word cannot entail legal consequences, especially if it's used by people who are not lawyers. And whether public engagement attracts legal obligations is a question of substance, not form. And that reflects a kind of long-standing legal principle generally, that you can't magic something with legal consequences merely by the use of words of it if it doesn't in substance amount to what that legal issue is. So in Liberty, the divisional court had said that the engagement exercise was a consultation exercise, and it applied what it described as conditions in the Evely judgment. So it said that Evely had set out exactly when a consultation would be a consultation. If you want to look at a judgment that had gone the other way, then the transactional judgment, which I've cited here, found that there wasn't a consultation from following an engagement exercise. That's the puberty blockers case that I was in, that Carine mentioned at the beginning. So in Liberty, in the Court of Appeal, Liberty argued the same as they had done below, that an engagement process is a consultation if there was a sufficiently crystallized proposal. It was likely that the proposal would impact a particular group, usually adversely, and the proposal was at a formative stage. And it said that those are the three conditions set out in Evely. That's enough to establish a consultation giving rise to the gunning requirements. But the Court of Appeal rejected that characterization of Evely in Liberty, and it said that the features which had been identified by Liberty were probably necessary, although it doesn't say in terms that it is necessary for a consultation, but they were not sufficient for an engagement process to be a consultation. And the court said that actually, if that was the case, then it would make a huge inroad into the hitherto well understood position that at common law, the duty to consult is confined to the limited and specific classes of case identified in the Plantagenet Alliance case. That's the Richard III judgment. Because it would mean that in a case where there was no statutory or common law obligation to consult, a decision maker would nevertheless come under such an obligation if they carried out an engagement exercise with any third party in circumstances that satisfied Liberty's three criteria, which I'd set out on the previous slide. And ultimately, the Court of Appeal said that whether a process constituted a formal consultation has to be judged by a wider assessment of its purpose and character. Although I have to say, the Court of Appeal judgment is a little bit opaque as to what actually might give rise to something being a consultation in that scenario. There was one other question sort of left over by this, which is ultimately that Coughlin principle. So if a voluntary consultation has carried out, so it's an engagement exercise that actually is a legal consultation, then what does that require? Does it require compliance with the gunning principles, as had been said in the Coughlin case? Now, in Liberty, that issue wasn't actually argued by the Secretary of State, but it had been in Evely, but it didn't actually arise for determination in that case. And essentially, this issue is left to be determined for another day. But in Evely, there was a sort of related issue, which was about whether the standard of review in a voluntary consultation case is fairness or irrationality. And the court said it's probably unlikely to make much of a difference because something that's unfair is probably also irrational, although that might not always be the case. And I would say where it's likely to matter is in how much the Court of Appeal needs to, or the court, whichever court it is, needs to defer to the judgment of a decision maker as to the fairness that's going to result. So, for example, I had a case where the High Court deferred to the judgment of the public authority as to whether or not parties would be prejudiced by there not being a further consultation on a particular issue. And that issue involved a sensitive area of planning judgment. And so the court said, well, really, who are we to say that this isn't going to affect people when the particular public body in question had come to a different conclusion? There are a few other interesting features of the Liberty decision, but relating to statutory interpretation, use of parliamentary materials. Just will flag one point on that, which is if you are going to refer to parliamentary materials in a way that would engage parliamentary privilege, there's a strong indication from the Court of Appeal endorsing what was said by the Speaker of the House of Commons and counsel to the chairman of committees in the House of Lords, that you really should notify parliamentary bodies that you're going to do it so that they can make submissions on the admissibility of those materials if they want to do so. So next topic, legal consequences of procedural breaches. Now, this is sometimes slightly surprising, but not all decisions reached in breach of requirements contained in legislation, which can be in an Act of Parliament or in secondary legislation, are necessarily unlawful. So breaching a requirement that you're supposed to publish something and you don't publish it doesn't mean that that decision is necessarily unlawful. And the kind of correct approach was established in 2005 in a House of Lords decision called Soneji, and it's been analysed in 4 Supreme Court decisions in really a very short space of time, and all started with the A1 Properties judgment in the housing context, which our colleagues Justin Bates and Harley Ronan acted in. And then there's been a string of other cases across multiple areas of law. So N3, which is about deprivation of citizenship in a JR context, Brown and Ridley, again, a property context, and Crown and Leyden, which is a criminal case. The kind of starting point was summarized in the N3 case as the legal effect of a failure to comply with a condition for the exercise of a power conferred by a statute where the consequence is not spelled out expressly depends upon an inference as to Parliament's intention as to what the legal effect should be. And this is essentially a principle of statutory construction. So you're not applying a rigid category-based approach to evaluating the consequences of a failure to comply with a certain requirement. Rather, you've got to focus on what's the purpose served by the requirement as assessed in the light of a detailed analysis of the particular statute following familiar statutory interpretation principles, and what are the specific facts of the case and what prejudice might be caused by such a breach that might arise if the validity of the statutory process is affirmed, even though there's been a breach of the requirement. And what the Supreme Court said in the A1 Properties case is that the statutory regime may reflect and balance a number of intersecting purposes, both as to outcomes and as to procedural protections in that particular regime, requiring a more nuanced analysis and weight to be given to individual rights affected by the operation of the statutory regime. That was quite obvious in the A1 Properties case because you have competing interests of, for example, different leaseholders in a right to manage context. So you've got the freehold, etc. In a public law context, you might have so in planning cases, for example, you might have the local council, you might have the applicant for planning permission, and you might have third-party objectors, all of whom have different interests, which the statutory regime is trying to protect. So this is a different question, though, from if the decision is unlawful, what remedy the court should grant in order to give effect to the legal right to judicial review. And in the Bradbury-Brecon-Beacons case, Lord Justice Lewis made this very clear, and he said these are analytically different questions because you really only get into the question of remedy once you've established that something is unlawful, but remedies are always discretionary in judicial review, leaving aside Section 31(2)(a) of the Senior Courts Act. And just while we're on this topic, I just wanted to briefly mention that the Lord Justice Lewis decision in relation to Section 31(2)(a) is very useful in explaining how the court should approach it. And really what he's trying to get everyone to focus on is the extent to which the error was significant in the decision-making process. So what impact did that have on the decision? It's not about predicting what the public authority might have done if it had not made the error, because you can't tell how it might have approached certain matters. Really, it's about understanding the significance of the error on the decision that was taken. And he gave a word of caution against relying too heavily on, and I'm guilty of doing this, principles summarized by Carine QC, as she then was sitting as a Deputy High Court judge in the Cavabienne case. That was a sort of classic situation where a judge had summarized all the cases. It's all very useful. We think, oh, brilliant, I just need to look at this one case. I don't need to go and read all those cases they cite. And Lord Justice Lewis says, oh no, you can't do that. You really do need to look at each individual case. These are not a checklist. Things can get taken out of context, and it's not acceptable to just rely on one case and not think about the fact sensitivity that give rise to different principles in each individual case. So that was section 31(2)(a). So finally, just briefly a comment on rolled up hearings, because this was again something that Mr. Justice Chamberlain highlighted at the seminar that Miranda mentioned that Mr. Justice Chamberlain gave to the Administrative Law Bar Association yesterday. And in the Al-Haq case, which is the judicial review proceeding through the courts right now, I think hearings start next week, against the UK's decision to authorize licensed armed exports to Israel. He explained how the court should approach a request for a hearing to be rolled up, so where you skip the procedural requirement to obtain permission before a substantive hearing, and the permission and substantive hearing are considered at the same time. And he set out a number of factors that should be borne in mind. And really those kind of are quite pragmatic questions about what utility would be served by a rolled up hearing. So is it actually going to result in a final decision more quickly? Is it going to be longer? Is it going to be a greater burden on the defendant? How much greater? So I would suggest, if you're ever looking for a rolled up hearing, that you take a look at the Al-Haq case and make submissions by reference to the factors that Mr. Justice Chamberlain identified in that case. So that's all from me. I think we now have time for some questions.
We do. Thank you so much to both Charles and Miranda for that very interesting and illuminating discussion of the cases that have, or certainly some very recent cases which have interesting principles to be looked at. This is your opportunity, if you're viewing, to send us some questions. We've had two, but before we turn to the two, just a reminder that you can just put your question in the Q&A section at the bottom or at the top of your screen. I actually had a question for Miranda, if that's all right, about anonymity orders. I think we're all slightly, it's out of our comfort zone, really, to know that we're going to have to work harder for anonymity orders. And I will certainly read the Elnor case with some interest. But in what circumstances then nowadays would an anonymity order likely to be appropriate in your view?
Great question. And I think that the key term we need to think about here is risk. Can you evidence an individualized risk? Is there a risk of harassment and abuse from the public? And if so, can you evidence that by factors specific to this case? Is there a risk, for instance, I referred to asylum seekers, is there a risk this person might be removed and their identification could harm them? I think, notwithstanding, Elnor, you are still on pretty firm ground with asylum seekers. Also, is there a risk if you have a very vulnerable client, and if matters that are extremely private, such as, say, details of their medical history, their mental and physical health, are going to be examined in detail, is there a risk that that's going to detrimentally impact on them? Similarly, there could be scenarios where there are risks to third parties, possibly in cases involving, for instance, domestic abuse. But what I've taken away from those two cases, and from what we've seen in the Admin Court Guide, is that I need to stop presuming I'm just going to get it because I have a vulnerable client or because they're a victim of trafficking, for instance. I need to be very clear and specific about the individual harm to them. And I need to explain why the impact on freedom of expression is justified, because the Supreme Court in Abbasi does emphasize that even if your client isn't some famous individual, press freedom is furthered by being able to put names to stories. And I think that's something worth sort of giving a lot of weight to when you're writing submissions on that point.
Thank you, Miranda. That's really helpful. The other question I had, and I promise turn to other people's questions in a moment, is about wasted costs. And now, my recent experience with, not with wasted costs, but with the use of AI, was where a litigant in person had used AI in written closing submissions, and then had mentioned a number of cases which didn't exist. And when it came back for a hearing, and the judge said, I can't find any of these cases. What is it? And then so, did you use AI? And the litigant in person was told effectively they had to go away and rewrite their closing submissions completely as a result. Now, obviously not appropriate in those circumstances to order wasted costs, but and you've already said, I don't think anybody on this call will need it, but if you were to be, if you've made a mistake, whether it's AI or something else, and you're worrying that you're facing an application for wasted costs, what's the best thing to do practically?
I think that's such a valuable question. One of the best bits of advice I ever got when I was a junior practitioner was, you're not going to survive in this job by not making mistakes. You're going to survive by making mistakes and recognizing that you've made them and fixing them to the best of your ability. And I think that wasted cost is a perfect example of that. Very often what you see in cases where judges are quite robust, as we saw in Allende, is people who've perhaps slightly put their heads in the sand, people who have, if not tried to cover up, tried to sort of minimize or distract from what is just quite a serious error. You hold your hands up, you tell your regulator. If you have any doubt whether you need to tell your regulator, just tell your regulator. It's always a good idea. I still have the Bar Council Ethics Hotline on speed dial in case ever needed. And I find that when people come to me having made mistakes, for them it seems existential, and to me it seems very fixable. And I think that often where things go wrong is that people, they see this as existential, and so they want to avoid it and not deal with it. Deal with it promptly, be upfront about it, tell the judge, tell your regulator, tell the other side, and explain what you plan to do about it. And hopefully most of the time, especially if it's, you know, a mistake rather than something deliberate, you will actually get quite a lot of judicial sympathy.
No, I entirely agree. Absolutely. All right, I've got a question for Charles in the chat. The purpose of a rolled-up hearing is to enable swift disposal of a claim. If the court fails to list the hearing within a reasonable or specified timeframe, or there is an undue delay, what remedies, if any, are available in such circumstances?
Yeah, I mean, I think my reaction perhaps suggests that there aren't really any, I'm afraid. It's a frustrating situation, and I think we've probably all had this, where you sort of get quite excited, oh great, the court's doing what we want it to do, and then everything just goes silent for so long, and you're just wondering what on earth is going on. I mean, I'm assuming this question is about whether the court fails to list a rolled up hearing within a reasonable or specified time frame.
Yeah, I think so.
I mean, the reality is the court is massively overstretched. Mr. Justice Chamberlain made this very clear in the webinar that we went to yesterday. And notwithstanding they have got significant resources, they also have a significant number of claims coming in each week. I think, did he say something like there's about 100 new cases in the admin court each week, which is really quite a lot. I mean, that isn't just JR, that's extradition, etc. But it's still a lot for them to process. I think really you've got to sort of keep on at the court and explain the importance of it. Ultimately, if the matter becomes so serious that parties are being prejudiced by the failure for there to be any hearing, you could think about making an application, and even in a very extreme case, an urgent application for consideration by a judge for a hearing. I would really counsel against doing that, apart from in the most urgent situations where there are really significant interests at stake, so significant commercial, significant public interests at stake, or private and human rights interests at stake. You could do that. Alternatively, you could, kind of complain administratively. and ask for the matter to be seen by a more senior person in the admin court office. Ultimately, though, there is an admin court users group. It's not really for this purpose, but if you have a sort of general issue where this is regularly happening, it could be something to take to that users group so that the court is aware of it. Mr. Justice Chamberlain made very clear yesterday that he wants to receive feedback as to how the court is going. So it's the kind of thing I think he would be interested in hearing.
Absolutely. And just to deal with Miranda's point earlier, that she's not suggesting that anyone tell the Supreme Court that they're wrong and that Mr. Justice Chamberlain is right. I think it's only a matter of time, isn't it, until Mr. Justice Chamberlain is in the Supreme Court himself, isn't it?
He can tell them that they're wrong.
Yeah.
All right. I'm turning back to the questions. A question about consultation from someone earlier. Is there sometimes a duty to consult before departing from a substantive legitimate expectation? And if so, is that an example of the duty to arise? Is that an example of the duty to arise resulting from conspicuous unfairness or something separate?
It's an interesting question. And I think it's one where I'm not sure there really is a settled legal position right now. In the kind of tripartite division of the three ways in which a common law duty to consult arises, legitimate expectation is considered separately from conspicuous unfairness in the Plantagenet Alliance case. But I know that there are some earlier judgments from Law Justice Laws which kind of slightly allied these two questions of substantive legitimate expectation and conspicuous unfairness. I think it's one where if you're working out what to do for your own case, I would probably just kind of phrase it in alternative ways, saying whichever way the court looks at it, ultimately what matters is there is a substantive legitimate expectation for whatever reason, and make sure you plead that properly. But also it does give rise to conspicuous unfairness, because I think in reality, the fine distinctions between these as a matter of legal theory are unlikely to make huge difference if the facts are pointing in the same direction. And really, these cases are one on the facts. So I wouldn't get too bogged down in the legal distinctions here, because I'm not sure it will actually be of that much interest to a High Court judge. Might be to the Court of Appeal or the Supreme Court, though.
Thanks, Charles. Someone has asked us a little bit about For Women Scotland. In case you missed what I said at the start, we were deliberately not covering this because it's a big case and probably needs its own seminar. I drew people's attention to the UK Constitutional Law blog post that Crash Wigley has written, which is excellent. Do either of you want to bite on the question, Charles or Miranda? Do you have any observations on the Supreme Court's approach to statutory interpretation in FWS, in particular re-examination of Parliament's intent and the Section 3 Human Rights Act duty, or is that just too big a question?
I was going to volunteer for the veteran question, so if Charles has anything he wants to say, he's very welcome to do so. But
I would say I have many observations. I think for me, and this is something that Crash's article really highlights, is the absence of any reflection on Section 3 was really quite striking. Even if the answer is we don't consider it adds anything to the analysis, I think it's really surprising it wasn't actually mentioned in the judgment. But I'm not
despite being raised by the Amnesty International written submissions, right?
It's very odd, actually, from a sort of human rights law perspective. But for me, another particularly interesting question is the role of the principle of legality in this. The court also dismisses the applicability of that here, saying that there weren't any common law fundamental rights engaged that would require consideration of the principle of legality that would affect the way in which the Gender Recognition Act should apply to the Equality Act. And I think I'm not sure it's quite as straightforward as that paragraph in the Supreme Court judgment suggests. I think there arguably were some common law fundamental rights that were engaged by the decision. I am hoping that one day I'll have time to write about it. I don't know if I'm going to anytime soon, but that's a flavour of my views on that for now.
Sure. Miranda, you said you wanted to come back on something, or?
Yes. Well, just reflecting on what Charles said, it is a striking reminder of why we have all that extensive case law on standing and the need to have individuals bringing cases so that you have particularized facts to assist the court. And I do think that's perhaps one of the issues with that judgment. But moving on to the slightly more uncontroversial area of fetching of discretion, I just want to answer the question where a public authority adheres too strictly to its policies, it's still the case that this creates a risk of a claim that the public authority is fettering its own discretion. The answer is essentially yes. Having a policy does not allow you to have a closed mind. You still have to be open to individual applications. And quite simply, if you're just rigidly applying a policy, that will quite likely lead to fettering issues.
Thank you. I can see in the chat that someone has asked for a link to the blog Read for Women Scotland case to be emailed. We will arrange that through Josh, who's also on this call. You can't see him, certainly. I don't think there are any other questions, and it's 1 minute to 11. I want to say thank you very much, first of all, to both speakers for that really, really interesting discussion. And secondly, thanks to all of you. I hope you found that useful. Josh will email you the link to both the presentation and the recording of this webinar. And we're really very grateful to you for your attendance. Thank you very much. See you next time.
Thank you all.
Thank you.